Specifically, I'll cover, so in brief, the law and procedure of financial remedy claims in England and Wales, the relevance of trust assets and disclosure of these, the powers of the court when dealing with trusts and trustees. So here we look at statutory powers, forcing disclosure, joinder, variation of trusts, and also key case law on treatment of trusts and trustees. And then practical guidance, do's and don'ts when dealing with English courts and lawyers. I now turn to forced disclosure. There are various ways to compel disclosure. So in summary, these are, firstly, an order for an inspection appointment for production of documents, and this can only be used against a person in this jurisdiction. Secondly, a witness summons or order for deposition before an examiner. This can be used against a person in this jurisdiction. And thirdly, the issue of a letter of request to a foreign court. And I'm going to now deal with these in a little bit more detail. Disclosure or inspection of documents first. An application for disclosure against a non-party must be made without notice and supported by evidence. It must be necessary in order to dispose fairly with the proceedings or to save costs, and must specify what documents are to be disclosed. And I've copied the relevant part of Part 21 of the Family Procedure Rules 2010 onto your slides. The trustee will need to state what documents are and where in its possession, and in respect to the latter, what's happened to them. Next, a witness summons or evidence. Part 24.2 of the Family Procedure Rules deals with this. The person must be resident in this jurisdiction. If that person is a non-party, then they can still be examined under oath before a judge or examiner before the date of a hearing, essentially like how a witness gives evidence at a hearing.